Hi, I'm Jeannie Franklin. I'm a Virginia mediator, and in this video I'm going to describe briefly what a basic mediation process is like. I should probably start by saying that mediation really is not a one-size-fits-all process. It can, and in many cases should be customized to serve as well as possible the particular contours of the dispute that is in issue and the needs of the parties involved in the dispute. I like to think that the challenge of customizing the process to work well is part of the art and skill of being an effective mediator. Nonetheless, there are these core or basic elements that will be tweaked in the process of trying to set the mediation up, and that's what I'm now going to describe for you. The first step that I describe as entry, or a screening, an agreement to try mediation step. And by that I mean I'm going to be finding out information so that I can judge whether or not I think that this is a case or a conflict that I should be mediating because I'm a good fit for it. Also, whether or not I think it is a dispute that is amenable to resolution. If the parties after this screening process agree to try mediation, we will enter into a written agreement to mediate. And then we move into the next phase called preparation. And this is something that I spend a lot of time working on with the parties and with their lawyers if they're bringing lawyers into the mediation. We want to make sure we have the right people identified and available. We want to have the appropriate information that might be useful in our discussions in the mediation, and we clarify some other details. I'm actually also using this preparation phase to build understanding, to build some mutual trust and clarification of how we will work together. Having gone through these first two steps, we then get to day of the process itself. And this is by and large going to be in person, a joint session. A couple of things start off the session. We review a couple of things that we've agreed on, some ground rules, how we will act during the mediation, how it will unfold. Then each party gets to, I call it storytelling, talk about how he or she views the situation that is in dispute and what that person would like to come out of the process with. I will listen very carefully, and I might ask some clarifying questions. After the individual has finished speaking, I will briefly reframe or summarize back what I've heard. This is a way of making sure that I've heard carefully, and again, that the person speaking feels he or she has been listened to. After that, I quickly summarize the issues that are in dispute and the order that I would suggest taking them up. If the parties agree with that, then we'll get to work. And we get right down into trying to craft some solutions. We do that first by brainstorming, that is getting ideas put forth that might be useful ways to approach a resolution. It's somewhat creative, and it's not judgmental. If you have been involved in brainstorming before, you know you suspend evaluation or judgment of whether you like something or not. We want to get quite a few ideas, if possible, before we start discarding them. And then we work at evaluating them, refining them, seeing what we have. This is a process that I will handle in joint session if it appears to be productive and useful for the parties. If not, we will break up into working separately. I will meet privately with the different parties. We call this caucus. As we go through this, either in joint session or in caucus, as we get closer and closer to a firm resolution, I may bring everyone back together at that point and summarize where it appears that we do have the grounds for a resolution. And we'll start to talk about what the agreement will look like. If lawyers are involved, I have asked lawyers to bring a model or a template with language in advance. That gives us a jump start. It is really for the parties and their lawyers to write the agreement, and I help with it. But again, it is going to be the parties' agreement and the parties' resolution. We may finalize the agreement at that time and the parties sign, and we can talk about some next steps. It might be that this isn't going to be just a one-time process for one day or for half a day. It might be that the parties are going to meet more than once, and we can plan for that. I'd like to wrap up this video with a few general points. Not all the disputes that I have facilitated discussions of or formally mediated end in a written settlement agreement, but I can say that the vast majority of them do. And in those that do not end with a written settlement agreement, I am told by the parties themselves that they nonetheless feel that they have made progress and that they come away from the process with self-respect and hope intact, having learned some ways to communicate better and avoid problems in the future. Now, it might seem a little strange to think of people who are involved in a commercial dispute, businesses, as wanting self-respect or having feelings, but in fact, that is a very real thing. If you think about it, when we believe something is wrong or unfair, our feelings are engaged. Similarly with businesses, owners, founders of businesses have created a brand, have created a reputation. They have invested a lot in it, and they are proud of that, and they guard those things. So it is important to them. Confidentiality I haven't mentioned, but that is a very important factor in the mediation, throughout the mediation process. We actually talk about it at the very beginning in that first step that I mentioned to make sure that everyone is very clear on what their expectations can be and what their commitments are to respect and maintain confidentiality. The confidentiality creates a safety zone, if you will, and has the effect of encouraging people to work openly and transparently. I found it to be very, very important. So coming back to what I said, even if a process does not end in a written settlement agreement, it does end in what I had hoped for, and that is that the parties feel that they have made progress, they are better off, and they are satisfied. And that is extremely important. Thank you again for listening, and good luck.